We are from Group 6 and will be present about question 1, which is the story is about Johan, Bruce and Mutu were engaged by Moonlight Productions Sdn Bhd as actors for a movie to be shoot in Kuala Lumpur. Johan is the lead actor and will be paid Rm 50,000 ringgit per month for his role. The shooting of the movie will last for 20 months.
Assalamualaikum. My name is Nora Amira Natasha binti Kamel. My matric number is S67817. For case 1 of the issue is whether Moonlight Productions Sdn Bhd is required to make a contribution toward Johan EPF is a matter of inquiry. Next, the rule is we use the Section 6 of Employment Act 100 1995, and for the second one is Section 2 bracket 1 of EPF Act 100 1991, and then the related case is about case of NG Swikin versus KFC Holdings Sdn Bhd, and the second is case Stevensons, Jordan and Harrison Ltd v McDonald's and Evans on bracket 11952. The application is Johan received his monthly salary of Rm 50,000. Moonlight Productions Sdn Bhd is obligated to allocate 13% for this sum in his EPF account. Moonlight Productions Sdn Bhd must possess a short comprehension of its legal responsibilities concerning EPF in contribution for its employee. The conclusion is based on Johan case, if Moonlight Sdn Bhd fails to meet this responsibility, may result in fines or legal consequences for the organization. Consequently, Johan can be confident that Moonlight Productions Sdn Bhd is mandated to allocate resource to his EPF as specified by the EPF Act 100 1991.
Hi, my name is Nur Hakimah binti Hamzah. My matric number is S60813. The question 2 about Bruce was negligent in performing a stunt while scaling down the KL tower. He injured her stunt hand when he landed on him. Is Moonlight Productions liable for Bruce's negligence? So the main issue for the question 2 is whether Moonlight Productions vigorously liable for Bruce's negligence when he injured her stunt hand while performing a stunt. And the second issue, whether Bruce is considered guilty for his negligence that injured her stunt hand. Next, the rule is according to Section 101 of the Malaysia Evidence Act 1950, the burden of proof for negligence on the plaintiff and the standard of proof is on balance of probability. That it was more probable that not the defendant was negligent. This means Bruce also cannot be proven guilty of his negligence because there is no evidence whether the negligence was purposeful or not. According to the case for Fiona v. Dr. Sofaman and Arnold, 207, the applicant who is facing an operation failed sued the respondent for negligence in medicine. The Malaysia Court affirmed the principle that employer can be vigorously liable for the negligence of the employers if tools and were closely connected to employers assigning tasks.
My name is Nur Batrisha Farhana binti Shahrun and my matrix number is S66267. So for the application, whether Moonlight Productions Sdn Bhd will be responsible for Bruce's action, according to the related case Fu Fiona v. Dr. Su Fu Moon and Annal 2007, the appellant who is facing an operation failure sued the respondent for negligence in medicine. This judgment affirmed it believed that an employer might be held vigorously accountable for its employees' negligent acts if those activities were directly related to the employee's assigned task. This is also related to employer-employee relationship that state vigorous liability is situation where an employer is responsible for the damage caused by the thoughts of his employees acting in the course of employment. Under common law, the employer has a duty to always protect the employee's safety at work, where an employee suffers injury at work due to lack of care by the employer. The employer shall be liable for negligence and the injured employee may claim for the damage. In accordance with the case of Bruce and Moonlight Sdn Bhd, Moonlight Sdn Bhd should be liable for Bruce's negligence because the negligence commit happened while he is playing his role. Bruce also cannot be proven guilty of his negligence because there is no evidence whether the negligence was purposeful or not. As mentioned in Section 101 of the Malaysian Evidence Act 1950, the burden of proof for negligence on the plaintiff and the standard of proof is on balance of probability that it was more probable than not the defendant was negligent. In conclusion, Bruce is liable for negligence, but there was no genie contract created between Bruce and Moonlight Sdn Bhd that state that whoever caused the damage is responsible for the negligence that is made by itself. Referring to the related case and employer-employee relationship, it is also mentioned that anything that happens while doing work will be the responsibility of the company itself. In this scenario, Moonlight Sdn Bhd shall be totally responsible for the damage that happens.
Hi, my name is Zain Anissa and my metric number is S66743. Okay, so for question 3 is Muthu was injured by a spotlight that fell on him during a shoot. Is Moonlight Production Syndrome Berhad liable under the Occupational Safety and Health Act and the Employee Social Security Act? The issue in this case is whether Moonlight Production Syndrome Berhad is liable under the Occupational Safety and Health Act and the Employee Social Security Act for Muthu injury. So for the rule, under Section 22, employees who experience temporary disability due to a work-related injury are entitled to periodic payment for the duration of the disability, as outlined in the 4th schedule. However, these benefits are only payable if the disability lasts for at least 4 days, including the day of the accident. The count of the 4-day period starts from the day the injury occurred, regardless of whether the employee was paid wages that day. In Section 24(1), an accident is considered to have happened during the course of employment if it occurs while the employee is commuting between home and work, traveling from work-related reason, or going to a place to eat during a work break. Under Section 29, employees who suffer an employment injury are entitled to periodic payment as determined by Director General of SOSU. Under Section 33A, if an insured person who have reported an injury or applied for a medical evaluation died before being examined, SOSU may at its discretion and based on available medical evidence, refer the case to a medical board for determination of the cause of disability or invalidity. Under Section 41, SOSU is authorized to promote health, safety, and welfare measures for insured persons and to support the rehabilitation and re-employment of disabled or injured employees. The organization may incur expenses for such measure within limits set by the minister. The case that related to this problem is case of Alamgir versus Cast Printing and Packaging Syndrome Berhad. The plaintiff, Alamgir, suffered a severe injury when his right hand was caught in the roller of a printing machine during a night shift. This case highlights the importance of workplace safety, proper training, and the maintenance of the machinery, as well as the potential consequences of an employee action on their own safety.
Before jump to the application, let me introduce myself. My name is Nur Farisha Natasha binti Muhammad Zamri. Matrix number S67062. So under the application, the case of Moonlight Production Syndrome Berhad, they may also be liable under the OSHA and could be penalized or be held liable for failing to ensure a safe working environment and failing to register Muthu with the Director General as required under SOSO. Muthu's journey to seek legal recourse begins with the immediate reporting of the accident to his employer. This would then be followed by seeking medical attention to diagnose and treat his injuries properly, as medical record will form parts of his claim. The next important point of action will be to notify the accident to SOSU so that his claim could be accessed for social security benefits. So based on the evidence and legal analysis, Moonlight Production Syndrome Berhad may be held liable under both OSHA and SOSU for Muthu's injuries. The employers lack to provide a safe working environment as required by OSHA, as well as probable carelessness in equipment installation and maintenance constitute a breach of duty. If Muthu feels that his OSHA rights have been violated, he can file a complaint with the Labour Department. This will be followed by an investigation, upon which, if the allegations are proved true, enforcement action against Moonlight Production will be initiated. Before the case is taken up in a court, Muthu may go through conciliation and the Labour Department will facilitate this to ensure an amicable solution or resolution is reached. In case conciliation fails, Muthu may have to use an employment attorney or a personal injury attorney. The lawyer shall draft and file a cause of action specifying the claims against Moonlight Production, outlining the breach of OSHA and prior for damage for personal injury. This procedure in court will then take several stages, culminating in trial in which both parties present their evidence. The court will then give its judgment, which will include an award for damage, order for corrective action, or other risk measure to be taken in the event that Muthu emerged successful in this case. Following that, this case highlights the crucial need for companies to adhere to workplace safety guidelines as well as their responsibility to protect their employee safety. Moonlight Production Syndrome Berhad must seriously review its safety protocol and ensure that all the equipment is well maintained in order to prevent the recurrence of any such incidents. It should also make sure that all its employees, including actors, are registered with the SOCSO to ensure that coverage in regard to employment injury. Doing so will help this business to avoid legal and financial implication of work injuries, besides reflecting a positive attitude towards health and safety among its workforce. As a result, Muthu may be entitled to compensation for his harm under Section 29 of SOCSO, and Moonlight's production Sendian Berhad may face penalty or legal consequence for breaching OSHA's responsibility and failing to register Muthu with the Director General as required under Section 40 of SOCSO.